Hello and welcome to this very interesting debate on LawWiser on emergency arbitration. In the light of a recent Supreme Court judgment on Amazon Future case, there's a lot of buzz around emergency arbitration, and we have the right experts to talk about different aspects of it. Let me start by welcoming our guests today. We have with us Mr. Gourab Banerji, Senior Advocate, Supreme Court of India, Mr. Sanjeev Gemawat, General Counsel, Dalmia Bharat, and Mr. Manish Lamba, General Counsel, DLF, Cyber City Realities. Welcome all of you to this panel discussion of LawWiser. I actually wanted to start with the initial reaction of each one of you on this judgment that has recently come. If I may start with Mr. Lamba. Shine.
Okay, so my first reaction is a big congratulations to Gourab Banerji and his team for this wonderful victory. It is certainly a very, very interesting aspect, both as a lawyer, if I read it as a student of law, as a lawyer, as a practitioner, or even as an in-house consumer. I think this is a fantastic judgment. What Law Commission did not or could not accomplish, or it suggested, and eventually it was not carried out insofar as the subsequent legislation is concerned. The Supreme Court has gone ahead and interpreted the existing provisions in a manner that today it is not necessary whether or not it was specifically there or not. I, as a student of law, always thought that Article 21 of the Constitution was flexible. Now I see even Section 21 of the Arbitration Act is equally flexible and it can encompass. So the debate was always there in my mind. I did not know whether I have attended several conferences after the Law Commission's report and after the amendments which were carried out. This lurking doubt was there in everybody's mind. I think that doubt has been put to rest. And there is a very interesting observation which I've seen in one of the paragraphs in one of the observation which has been quoted is that you cannot put a round peg into a square hole. Mr. Salve and this Justice Rohinton has actually quoted that. So that evoked me to look into what does it mean. This phrase came in the 18th century, rather 1800. And thereafter, I was surprised and amazed to see that, yes, it is possible to put a round peg into a square hole. And this is exactly what the Dutch settlers did when they went to US for the making of the houses. And even the railways, when it started in US, they used to, in order to stabilize the rail steel, used to put round pegs to square holes. So probably this argument which appeals to the mind otherwise, whether this can be done or can't be done. And I was also in one of the satellites also, when one of the oxygen thing, and this is all in Wikipedia, it's just 2 days old knowledge that I have on the subject. And that makes it interesting. And the interesting part is, yes, as lawyers, we need to be very sure that even round pegs can be hammered into square holes for meeting the ends of justice.
Sanjeev, I would actually go over to you to take your initial reaction on this before I move on to Mr. Banerji.
First, thank you, Aman. Thank you, LawWiser, for inviting me to share my views. I think it's a great initiative, that too for a very, very relevant subject. My all compliments to Mr. Banerji. For me, he has always been the master of arbitration laws in India. So many congratulations, Mr. Banerji, to you and your team for doing a nice thing with regard to the arbitration mechanism and the various initiatives which you have taken. As regards this emergency arbitration concept is concerned and the recent judgment is concerned from an industry standpoint, I can very well say that it's a very, very welcome judgment. There is no doubt about it. And what industry wants certainty. Industry wants quick and expeditious resolution of issues. And from that perspective, it gives a broader guidelines in terms of how the arbitration law would be structured in the times to come. So I think from that perspective, it's a very good development. But at the same time, it poses a few questions as well. And the few questions are that, yes, one is the public opinion is now getting framed that whether it was right on the part of the legislature to not amend the Arbitration Act, or whether a public opinion is getting framed that in the times to come, perhaps there's a need in terms of a specific provision under the Arbitration Act. I think that is the issue which we need to deliberate and make that public opinion that in the times to come, we would be perhaps needing that. Also, it poses another question that should we be putting all these critical issues which are too relevant for the business world, for the subject matter of interpretations by the courts? Answer is perhaps no. And if you see that the judgment is, it's referring multiple sections, and those multiple sections are ultimately culminating into what this order is all about. So should we be putting all these things, subject matter of interpretation? I think answer is no. So with these initial comments, I think we can initiate this discussion. Thanks.
So Sanjeev, as I understand that basically you are in favor of including emergency arbitration in Arbitration Act by the Act of Parliament. I'll now move on to Mr. Banerjee, and like everyone, I also wanted to congratulate you on this landmark judgment. I basically wanted to ask you that what is the validity and enforceability of such judgments, because parties which get adverse order run to courts, then what's the point? And that's where again the point raised by Sanjeev comes into the picture, that it should definitely is it needed that you definitely put it under the Arbitration Act or not? But I just wanted to have your initial reaction first, and then your viewpoint on validity of such kind of awards.
So thank you for inviting me to talk about this. Obviously, I have a little bit of a biased view because I was appearing for one of the parties, but keeping that aside, thank you for all the congratulations. It was really a team effort. Picking up from what Sanjeev said, interestingly, both Justice Nariman and I contributed to the 246th law report. If you see the introduction, he wrote a letter, and I also made some contributions. And we had this debate about emergency arbitrators informally. Justice A.P. Shah, I think, did a wonderful job with the report. And frankly, there was a gray area. And the judgment could, in theory, have gone another way, because there was a lack of clarity in the definition of what is an arbitral tribunal. What we had suggested is 2(1)D should be amended, and specifically with reference to SEAC rules. But the legislature didn't do it. I was part of the legislature also at that time, so I may have to take part of the blame for that. But the interpretation ultimately given by Justice Nariman is that the Law Commission's report is really not relevant if otherwise the Act can sustain emergency arbitration. And obviously, he took a very pro-arbitration view. He emphasized party autonomy. He interpreted the sections, but that's the legal aspect of the matter. So, is it a good judgment for arbitration in India? Yes, in the sense that if you sign on to institutional rules, and we have institutional rules let's leave SEAC out for the moment. We have similar rules in the Delhi International Arbitration Center. We have similar rules in the MCIA, Mumbai Center of International Arbitration. We have similar rules in Madras. So obviously, and DIAC is next to the Delhi High Court. So obviously, if parties want a solution and they, with open eyes, sign on to such a solution, then the courts should support it. Having said which, ideally, there should have been an amendment. So that's my first reaction. But more to the point, and maybe we'll come to that later, this is a job only half done. Because picking up from what Sanjeev says, in the Arbitration Act, there are two parts, which part one is for domestic and part two is for foreign. This judgment only addresses part one, which means that it only affects India-seated arbitration. So a lot of people are very confused about this. The moment they think of SEAC, they think of Singapore, they think we have all gone off to Singapore and the arbitration in Singapore. No. The arbitration is a Delhi-seated arbitration. merely SIAC rules are being applied. So within India, for domestic arbitration, emergency arbitrators there, excellent idea. It will decongest the courts. So that has solved the problem. But unless there is some legislative intervention for foreign awards, I'm afraid there is another gray area, and we can come back to this and I can discuss Raffles design, etc. So good judgment, but necessary for the legislator to step in to give clarity for at least part 2.
Now, I would actually, go to Sanjeev now to ask for his comments that, going forward, what actually parties need to consider with respect to emergency arbitration in the contracts, etc., that they do in future.
Well, Aman, in my view, I echo the similar sentiments as Mr. Banerjee is pointing out, to start with. But then I know it for sure that arbitration is one such area which is having multiple ups and downs in the last 2 decades or so, which we have experienced. And I think that the courts, in their own wisdom, passes at times certain orders which would further confuse the whole issue. So from that, if I just go by this logic, I think while drafting the arbitration clause, we will have to have a complete clarity that what we are entering into. Now, from that perspective, if you ask me that as a general counsel, should I be, referring the provisions relating to emergency arbitration in my contract? Answer is definitely yes. Answer is definitely yes, because that would give that level of clarity, because I'm not really very sure how this judgment would sustain in the times to come. Because I have seen, just take example, if we are talking about the Arbitration Act, the way in which Section 34 or public policy has been interpreted for the last 2 decades, it's complete zigzag manner. At times a widest interpretation, at times an narrowest interpretation. So I'm not too sure how the things would evolve till the government comes out with the changes as far as the legislation is concerned. So from that perspective, my recommendation would be that yes, we need to have a complete clarity in our contract, and we need to specifically provide the emergency arbitration related provisions, particularly wherever we are going for the institutional arbitration also. And even if the institutional arbitration is providing that emergency arbitration mechanism, still I would prefer that let the emergency arbitration related provisions should come in the contract. Why I'm saying so? There's another reason to this also. For example, take this case. What was the need for going for the emergency arbitration? When you have a Section 9, the Section 9 also provides you the equal remedy. There also you will have to appoint an arbitral tribunal within a 90 days period, I think in the SIAC rules also. The similar mechanism is provided in the Section 9. For the simple reason that you believe that perhaps Section 9 might not be the right remedy due to the courts are completely busy with multiple issues, and so you go for some certainty and some expeditious resolution, and so you follow the institutional mechanism for these kinds of interim protection. So from that perspective, also somebody should not be challenging this in future, and that's the reason I would strongly recommend that arbitration clauses should be properly worded and should have all these options available in the contract. Yeah, thank you.
And do we have the consensus from the other GC also on the panel, Mr. Lamba?
See, after this judgment, I need not do anything insofar as my clause of arbitration is concerned. As long as I say SIAC, MCIA, or the Delhi, that is enough. So nothing is required. But as a student of law, certain issues arise, which Gourab also agrees to an extent, that insofar as what legislation, tomorrow in law schools, there would be a question whether this was judicial legislation or it was a judicial interpretation. Of course, the manner, beautifully it has been done, it leans more towards the fact that it is interpretation, the manner in which Section 21 and 21D has been interpreted. But we are today sitting on a if I just look back, we had a wonderful opportunity when the Law Commission made that kind of a suggestion. We ignored it. We did not do it. And when the matter came before the Parliament, we did not do it. We did not make those changes. Gourab has partly taken the credit for this judgment being a part of the team, and partly is also taken the discredit for not having had this amendment being made. But this issue was there. So this issue would not have arisen had there been clarity. So we have almost always done a half-good job insofar as legislation is concerned. So legislation aside, this should have been done. Nobody is arguing today. The point is not whether or not emergency arbitrator is a good thing. Everybody rushes to the court under Section 9, Section 39, 1 and 2. And therefore, insofar as emergency arbitrator is also concerned, it is in aid of. But in totality, if you look at it, this was a fight. Since I am not an interested party, I can say this is a fight between the richest man in the world and the richest man of this country. As a result of which, to answer Sanjeev's question, that why you don't go to Section 9 and then you would have gone to taken an interim award, not challenged it insofar as the emergency arbitrator is concerned, taken a view, filed a suit, and then this entire process of 17-2 and right up to the Supreme Court would have been taken. Now, this raises a larger question. The larger question is that everybody cannot afford this kind of an expensive exercise, this kind of an academic exercise which has happened, is that insofar as the interim award being challenged right up to the Supreme Court, 250 pages being written by the Delhi High Court, 104 pages written by the Supreme Court, it is just an academic exercise. As a consumer of arbitration, I feel threatened, I feel nervous, the manner in which we are going, and even if such a small provision needs to be taken right up to the Supreme Court from October to this date, in less than 9 months, we have seen all the courts, all the methods, and so much of legal literature has been, it makes me very nervous. It makes me very nervous. Now, whether or not this question is going to be challenged like 34, I don't think so. Emergency arbitrator is only for that intervening period before the actual arbitrator is appointed, and he can confirm, amend, rescind, change, do what it likes insofar as this matter. This is one of the rarest of the rare cases in which Gourab Banerji has got the distinction of appearing and succeeding. No businessman is going to go through all this. If somebody chooses to go through it, good luck to him. But otherwise, it raises a lot of questions that what have we done with arbitration? Is nothing going to get settled till it reaches the Supreme Court? If that be so, then the very purpose of expeditious hearing is absolutely failed. The amount of money which the parties would have spent and time, effort in reaching this kind of a small matter, I think we need to look at the rule of law, the manner in which we look at contracts after signing them, what do we do with them, and how honorable we are insofar as our behavior is concerned. So the question is, as Gourab very rightly said, had the facts been different, not so gross, if the party would have applied for insofar as the appeal against that order is concerned of the interim order, or that interim order would have inculcated into a order by the regular arbitrator, what would have happened? I think we have made a huge big mess of the entire situation, but that's India. Welcome. That's what we do.
So if I can pick up on that and say this, that so far as this amendment was concerned, it was again debated in the Sri Krishna Committee, which is 2019, where his view, and his very interesting view is, his view is the view which has been accepted now by the Supreme Court. He was of the view that it was not necessary because of Section 70 for domestic arbitrations. But my point is a very simple point, and to that extent, I agree with Sanjeev and Manish. It's a very simple point. All other countries amend their arbitration law quickly. This 2015 amendment came after 96, after I must have been personally on 6 committees recommending change. AG's committee, Law Commission, Government of India committee, etc. 2015, one set of changes came in. They were good. Of course, there were some misses like this one. Then 2019, another set came in. They were not perhaps as good. Again, we had an attempt on emergency arbitrator. But if you see the 2019 recommendation, what Justice Sri Krishna says, please at least amend for foreign seated arbitration. Even that has not been done. So today, the main problem I find is, I mean, so far as India is concerned, the story is over. The Supreme Court has decided, it's over. So I don't think it is to be reopened. It is over. Emergency arbitrator, order under Section 17. You have a right of appeal under 37. Matter over. I think
Dada, you look at the kind of people who have manned the Law Commission on arbitration. Justice H.R. Khanna, A.P. Shah, Shri Krishna, and we had the finest of the brains there. But then legislature failed us. Had they provided?
I actually don't think the legislature has failed you to the extent that it has actually brought in 2 sets of amendments, and it's only a matter of industry persuading legislature to bring in further amendments. My problem is that these reports by Law Commission and by Sri Krishna, etc., sometimes they are over academic and they do not have enough industry input, is what I've seen in, at least in the second round. It was much more government oriented.
If I were to give you a practical sense what has happened, I'm not on the academics, I'm not on the merits, I haven't read the file insofar as I don't know the facts. But look at the manner in which this matter has traveled. If the certainty would have been there, the courts would not have been burdened. If the certainty would have been there, if the matter would have settled at the single judges, at the level of single judge, things would have been different. We are very bad losers. We come right up to the Supreme Court for everything. Now you look at it, what has happened. Insofar as if you look at from a commercial and economic point of view, I'm not on the legal point of view. I can't find fault insofar as the legal part is concerned. 25,000 crores is the banks which owe to the future. I'm just quoting from the newspaper reports. That merger which was about to take place, which has been stayed by the Supreme Court. I'm not on the economic part of it. What will happen today, insofar as after this judgment, I don't think so. The valuation would have been entirely destroyed. Banks will lose around about 25,000 crores. They may get 2,000, 2,500 crores if this matter was to go to NCLT. If the company was to become bankrupt. So I think between a bankrupt company and a bank, now if you look at para 61 also, the parties who are not before the court have not been considered. There was a bankrupt party and there is a bank. And that bank will lose 25,000 crores. I hope some business solution comes out of it. Something happens. We don't know. Business will come out with creative situations. But what we have done has put 25,000 crores to risk. I'm not saying that what is done is not right. But what I'm saying is that these business problems may not always have legal solutions. You please see, there was a stay insofar as the amalgamation was concerned. Had that amalgamation taken place, of course, the parties have to fend for what they did and then they have to pay for what they did not do. If you choose to lend to people who do not honor their contracts, then you will suffer. But banks will lose 25,000 crores. And eventually what will happen? My father, who gets puts a FD into the bank and gets 6.5% of interest, will now get 6.25 because there's a shave of 25,000 crores insofar as the banks are concerned.
You see, that's a very different debate. Then you go from arbitration to mediation and commercial.
Yeah, so I'm saying that it is not a panacea.
I also don't want the commercial solution.
I am also not commenting. I'm only saying.
I'm only some of the commercial discussions. So obviously,
I'm only saying insofar the time frame, and this is how we do it. Ultimately, everybody has to look at it very, very practically. Theoretically, I cannot find much of a difficulty there. But the parties who are not before the court are the ones who are the losers.
Okay, we are actually running out of time. So I will be actually going to, Sanjeev, for any concluding remarks on this entire debate so far.
Well, from a concluding remarks standpoint, I would continue with my initial remarks only. And I think that, yes, it's a very good development. But at the same time, I strongly believe that public opinion is now getting framed, that we need to have at times quick legislative changes. And this is what happens as far as developed or aware nations are concerned, that public opinion gets framed and then laws get framed. So I think that we are now at that stage. As Dicey has written in that laws and public opinion in 20th century England, I think that in developed nations, public opinion first gets framed and then laws get framed. And I think we are at a similar situation, high time in terms of legislative changes. I would also say that even from this interplay of Section 17 and Section 37, I think there also that amendment is required, because in my view, there is a confusion as far as interplay of Section 17 and 37 is concerned. So with these closing comments, I would say that yes, we are going ahead as far as the ease of doing business is concerned, making changes in the laws, making more certainty as far as the framework is concerned. Thank you.
Thank you. And Mr. Banerjee, I wanted to request you to cover 2 points in your concluding remarks. And of course, whatever you want to add. One is that how do you think is the investor confidence, confidence of your clients, after this judgment has come? And secondly, by when the legislative change can happen, if you have any view on that?
So I think, generally, and of course, I will defer to the 2 other panelists. I think generally, this has been taken as a very positive development that we offer this service of emergency arbitrator in India, which will go a long way in decongesting Section 9 petitions. So I think the judgment is obviously been very well received, quite apart from the Amazon dispute, generally by my clients, generally because I think it's a very positive occurrence. But secondly, echoing what Sanjeev and Manish said, we need some legislation to fill in a lot of gaps. I have a lot of thoughts on this, particularly in regard to emergency arbitration. We need legislation to bring in the ancestral model of 2006-17 HIJ, which will ease matters. There are other gaps to be filled. I think the government can do this by ordinance. I think there are enough models around the world. Other countries react within 6 months. Maybe we can react within a year or 2. I don't think the government is negatively inclined. It will help ease of doing business. So if industry and other people can put pressure on the government, I think that is really the way forward, the solution. Otherwise, we will have to think of the Amazons and the Justice Narimans to fill the gap. And that's, as Manish said, a very painful process. And you may not get the right result at the end of the day. It's like band-aid solutions. So great judgment, but it's only a halfway step to a complete solution.
Okay, thank you so much, gentlemen. With this, we come to the end of this panel discussion. Thank you so much for being a part of it.